All right, guys. Peace, love, and law to each and every last one of you guys. Welcome to In God We Trust Academy podcast, and we give thanks for you guys' participation as always. Right? Where you guys dropping in from right now? Let us know your location. Drop some ones. Let us know that you're with us. We're gonna kind of pick up from where we left out earlier today. Don't forget to follow us on YouTube. In God We Trust Academy is our channel. So you definitely can follow us there. You want to be able to see the screen, etc. If you're looking from other platforms such as TikTok. Other than that, though, man, hope everyone's doing great tonight. What y'all on out there? All right, so, man, let's jump right into this, guys. Trust administration and basically the hidden bank ledger. Um, as we have been explaining to you guys from the very beginning, that all things are literally within a trust relationship when it comes to um, knowing who and what you are in playing this, what I call the American game, right? Because the United States itself is a corporation. If it's a corporation, it has to have some type of shareholders. So, who are the shareholders? And that would be the people, right? Um, and we also have to be knowledgeable of what is taking place and what to be able to do about these different things. And we're going to continue on from that. So since we know that the United States operates in commerce, and I'm figuring you're like, okay, well, how do we know that? Well, the simple, easiest way to know is look at the money or what you call money and that you spend every day if you have it in cash form. If you have it in cash form and you read it, it literally says this is a Federal Reserve note. Note meaning a promissory note, a form of negotiable instrument that, according to the UCC, right? According to the UCC, it is considered to be commercial paper. So, with that being said, we know that the United States is operating as a form of a corporation based upon bonds and other things like that that you can deal with, right? So we're going to do a few things with you guys today, and we're going to explain some things to you guys from trust and also dealing with banks. We're going to do a little bit of both today. Okay? Now, first, we're going to start with who you are. You are the people, the sovereign people who establish government. You are the people who rights already existed. A government did not grant you a right. Okay? And what I mean by that is the right to breathe. Just breathe. There's not a government that can stop you from that particular right. That is a inalienable right, right? The right to life. Breathing is part of that. Okay? You have the right to shelter. It's part of life. You have a right to shelter. You have a right to all resources of this earth, right? To the benefit of yourself. You have a right to that. Okay? That is an inalienable right. So once you understand and establish that part, just know that we took these particular rights and they created what they called a government to establish, to protect these particular rights. Now, let's just be honest. When it comes to the United States Constitution or the United States, it did not have the Negro, Black, African American, or even women that was literally considered to be involved in this social compact. Okay. So we move on years forward, of course, after 1865 and things of that nature. Then they created what they called the 14th Amendment and so on. Right. And they made the states. So what they did was they made the states have to accept what you call the Black African American social construct people, right? And this term that was given to them was literally is a social construct. It is not exactly who they are when it comes to nationality or tribal people, etc. Right? It does not truly define them. It defines them in a process of naturalization coming. So anyway, that happens, right? And what they did was they started classifying everybody into that particular classification as if everyone is operating on a social construct status like white, black, like Hispanic, all of those type of different things, American Indian, or Native American, however it says on those particular, all of these statuses that they have given was through social construct of this particular state, country that has been established. But the truth is this: you are the people, and the people exist on the land, and the people have a right of soil. So you become the national by having the right of soil in whatever particular um, state, republic, state, territory that you were born on the land, right? So what that means, that makes you an Alabamian, a Floridian, Californian, uh, Mississippian, a New Yorkian, so on, New Yorker, wherever you want to go. My point is, it literally brings you into the aspect of knowing who you are as the people, and that is by the right of soil. Now, right of blood has a lot to do with, you can go back to tribe, you can go back to descendants of whoever, because if you say Chinese American, Chinese by blood, American is their right of soil, meaning they were born on this soil in some particular republic territory. All right. But anyway, that's just based upon who you are in this system, right? So now you have this um, commercial entity that they give you to be able to operate in commerce within this economical system in the United States corporation. So, and you are to literally place your human capital in this particular entity. So this particular entity is taking human capital and is transferring that energy into this particular legal fiction, which is your social security and so on, right? That you have. And that human capital is being transferred into a form of energy and being valued through what they call commercial papers, right? Through bonds, through promissory notes, through et cetera, right? So the main thing for you to know is that that legal fiction that they gave you, it holds all liability to everything. It's literally a subject owned by the state and the United States, and what they get to do is just, I mean, they can tax it, they can make it, it's a debtor, they can use it to pay for debts, whatever they want to make it do, they have the right to do it in that particular process. So we got to be smart about this here. So that literally means that we should never want to own any form of property in the name of the all caps, like ever. Why would you want to? Number one, I always look at it like this. No matter who's watching me right now, you could die right now, today. This very moment, minutes, seconds, poof, you're gone. Whatever clothes you had on, got on, or clothes you had, or cars, or jewelry, or whatever the case, somebody else is wearing that the very next day. Okay? So whatever land you thought was yours, it's going to somebody else. Somebody else is going to be occupying all of your form of tangible assets and so on. So you need to start realizing, okay, I don't own a damn thing. I just have control and I have the beneficial use of what I have right now. That's literally my standpoint that I have. And just reality, just looking at it from that standpoint. So there's nothing else that you guys can go out here and do. You can't own anything. You can occupy stuff, but the truth is we don't own it because we're going to soon pass away from it. So the only thing that we can do is make sure that we transfer this and build this for the next generation, the posterity, our posterity. We have to do that, right? Because other than that, none of this means anything. It's just a dead end for real. So unless we building for the next generation to continue to have and to continue to thrive throughout their livelihood, then what are we doing? Because you can't own it. So the best position to do and operate from is from a trust standpoint. Place everything into the trust. We don't own anything. We do have all the benefits and rights of interest to use it. Let the trust own it. So now what we're going to do is let the trust own our capital, our human capital. We're going to let the trust own any tangible, intangible property of the estate, the legal fiction. So that means that if you go and you buy a car with the legal fiction, the trust owns it. All right. That means a house, the trust owns it. So on, so on, so on, whatever it is. Then not only that, okay, let's say that you are a firm and true believer in your religion, etc. Now everything that you do is for religious purposes. That means your car is used for religious purposes, your home, everything about you, clothes is based upon your religious attire. So that's what you buy, etc. And remember, these clothes that you don't even own, though, the trust owns it. The trust owns everything, the food, all of it. Don't care what it is, the trust has to own it. Because at the end of the day, something happens to you, we're just going to be passing this on to somebody else. So what's the purpose of the trust owning it, right? I mean, what's the purpose of you owning it when you can just be a trustee and in full control of everything? All right. So now we have to look at it from this perspective now. So now we only know that we're dealing with the United States through a legal fiction. Okay. Now, how do we protect ourselves from the legislative codes that applies to this public entity? Easy, simple. We have to truly be able to decipher that from our position of who we are, coming from being the actual people, the grantor who granted the government, okay, these particular things on the benefit of another, which is the people, ourselves, right? So the Constitution itself, it's a trust indenture. Here we go talking about trust again, right? So we need to learn how to administrate the Constitution as a trust. Whatever that it says is what has to be. Here's the thing about it, guys. There is no such thing as they get to interpret. You don't get to interpret the Constitution. What it says is what it means and what it is. It's not what you thought it meant. It says what it means. Okay? That's the number one thing. So we have to remember that. It didn't leave a open. So one way, what I mean by that is, and I've been using this a lot here lately, but due process of law is very important. So if we're going to exercise the Constitution, you will go in some courts and they'll be like, hey, this court doesn't hear constitutional matters, or there's no room or whatever for the constitutional law here. You just have to know how to express it in a way. So that means you have to be able to challenge it according to the court rules, because the court rules is a part of due process. So that means we're going to look at the rules and procedures of the court. Simple method. Once you look at the rules and procedures of the court, we're going to administrate that particular trust. How do we do that? Okay, well, if it's, I don't know, some small traffic ticket, right? Well, in pretty much every state that I've come across, traffic tickets are treated like criminal prosecutions. So if a traffic ticket is a criminal prosecution, the Sixth Amendment all criminal prosecutions have to be held by an impartial jury, right? It has the right to a speedy trial. That has to happen. It said all. It didn't say some. And not only that, it also says it within the state constitutions, right? Because the state constitutions has to be in harmony with the U.S. Constitution as well, too. So once you look at it from that perspective, we're going to exercise this particular trust from the living standpoint, because the living man truly understands and knows the law. That's the difference. It's not a theory. We're going to exercise the actual law through due process, the rule of law. So now we give our affirmative answer here, an affidavit. Now, an affidavit is just not the end of it. A lot of you guys think filing an affidavit is just it. No, affidavit is just a facts or just pure evidence, because it's knowledge, firsthand knowledge of what you know about. Not only that, we can prove. So usually if we got an affidavit and we got some evidence to go along with it, which means that you are evidence as a witness to the situation with yourself. But in this affidavit, one, we're going to state our political status. Two, we're going to tell exactly what happened during the altercation or conflict of interest between you, the officer, et cetera, through the traffic ticket. And then three, we're also going to mention how this particular court does not have the power to give a impartial tribunal with the jury. They don't have the power to do that. So we're going to place all of that into the affidavit. Now listen to me, because what I'm telling you is just fully exercising. That's the difference. So once you exercise this and you let it be known, we have to preserve the record, because we want to make sure that we keep everything in line and ready for the appellate court. Okay? So when we preserve the record, right then and there, we do a motion to dismiss. That motion to dismiss is the challenge jurisdiction that everybody's looking for. Because in our affidavit, we've already proven how they don't have the power to do so. We can even take the law and enter in the law as well. We can give a judicial notice, to be honest with you. Give a judicial notice and place the judicial notice on the record as well as evidence. And there you have it. Motion to dismiss to go along with it. That motion to dismiss and the evidence and affidavit, all of that is actually challenging the actual jurisdiction. Because what we're doing here is, one, we're removing the subject matter. We're removing, we need to either change the venue where we can get a impartial tribunal, or they have to dismiss the case. And then our next thing to do from there, well, we need to do a motion of production. So everything I'm saying to you is just the trust administration and being able to administrate the trust. But not just that trust, your trust. Now, that's just on the actual living man side. So let's talk about the trust. Since we gave the trust all of our human capital, we can go straight to the actual clerk of court, give a notice of secured interest. And we're going to say, hey, we have the name trademarked. If you have your name trademarked, or maybe you place that over and et cetera, right, into your human capital, into the trust, whatever that you have. And you also can have a security agreement as well, showing that the trust is a secured party over the actual legal fiction, which can be the debtor, based upon the trust offering administration, suretyship and things like that for the particular estate. All right, so that could actually be the deal. So anyway, what we're going to do is, once we perfect the interest from the UCC1 as well, we're going to send it coming from the private trust, letting the actual clerk know that we have interest in any and all bonds, and we have first in time, first in right to receive those particular to receive those particular interests or principal dividends and principal payouts that may come from these particular bonds, or any money that's going to be involved, any monetary value. We have the right to that now. Okay? So now we just operated on both public and private. Privately through with the trust. On the public side, we actually did that through the courts, exercising our private right. And we challenged jurisdiction in a way where we didn't have to come in and say, hey, I'm not the name, I'm not this, I'm not that. You don't have to do all of that. They're going to know exactly who you are when you start exercising according to the rule of law. And that means whatever the letter of law says, and you operate within that capacity, and you're still able to assert these things and remove subject matter, then you can always challenge jurisdiction easily. So that's why if you go to an arraignment, say not guilty, and then just say based upon violation of due process of law. So now, once you say violation of due process of law, you're letting them know that your claim is that you are removing subject matter jurisdiction. You're also removing territorial jurisdiction. You're also removing personal jurisdiction, because there is no claim here that they got to stand on, because their procedures can, number one, violate you, or they don't have the right evidence to prove their accusations against you. That's it. That's challenging jurisdiction. But that's also exercising and administrating the trust. So you need to learn how to do both of those, right? Because there is a hidden ledger. Even when it comes to the banks, there's a hidden ledger for you. Have you ever noticed that when you go to and get bank accounts, that they always give you a certain amount of interest or percentage a year based upon using your money? It's usually at the end of the year, they give you a few dollars, $5, $6, probably less than that, 35 cents, a dollar, just depends on how much money you had in the bank. But what you need to learn from there is that, one, we're operating on the Federal Reserve System. And the Federal Reserve System operates on what you call fractional reserve banking. So that literally means that if you put $1,000 in the bank, they can go and create 10,000. Okay. So that, according to GAAP, that means that the journal entry will go in as 1,000. That literally gives them an asset as 1,000. And that means now that they hold a liability. So really the money belongs to them. You no longer own the money once you deposit. The bank owes you a number. They do not owe you the exact same cash they gave you. The bank can now lend against your deposit, and you do not receive any of the interest or profits, no more than what you agreed to when opening that bank account. So let's say that you put 1,000 in and they created 10,000, and then they only give you 5 pennies, 5 cents. That's how much they're going to give you in interest off of that, right? Because you did an interest-bearing account. But if you go and do a non-interest bearing account with a trust, and you got to understand, if a trust deposit its money, okay, that particular money that's being deposited from the trust is an asset. If you use the trust property, you have to compensate the trust. I don't care who it is. So now, if they use it, which they are, you get to literally do a notice of secured interest in this particular, in the money. So now you could do a, 80-20 rule. You get 80%, they get 20%, whatever the case may be for you. And you can literally make a full claim on all of your deposits at the end of the year, right? You get to do that. So it's totally up to you, but you also need to learn how to know what a 1099-B is and how to operate that, and literally make the right filing on the Schedule D as well as the 1040 and things of that nature, because it matters if you know how to file it correctly, because it definitely is possible. You definitely are making a contribution. You have to understand that everything is fully lawful. I'm going to show you, because we're going to talk about common law. A lot of people talk about the bank statutes and stuff like that, but that has nothing to do. You got to understand common law supersedes a lot of stuff, because it goes back to the Constitution and the protection of rights of the people, what is equity, right? It could say they don't do this, or they're not going to do that, or they don't have. Yes, they do, because equity demands performance. If I take your car and drive it and make $100,000 off of it, and I come back and I told you I used your car and I made $100,000, I filled your tank back up. You're not gonna. Equity demands that I give you a certain percentage, right? So how much of me using your car allowed me to create that money? Even if I had to give you 50%. even if I had to give you 30%, whatever the case may be. But that is what was supposed to happen based upon, equity. But when it comes to trust, then it would create what you call a constructive trust. So they would have to pay out anyway, but you still have to know about the administration of the trust. That's why the trust administration is so important. You have to know how to administrate the trust to be able to protect its property, its assets, and things of like that, and make sure that you're fully going to get paid that what you are owed due to the leverage and use of your property. All right. Very important things that you got to know. And when you don't, it's going to cause you harm. I promise. And I don't like to cause you guys harm, but you will. Somebody asked a question. Can a landlord be held liable knowing of a crime and not saying anything about it to the law? No, because they don't have to be a witness to something they don't want to have to be a witness to. Now, if you can prove that they were involved and had something to do with it, then you could say something, but they don't have to say anything. Can't make nobody tell that don't want to tell. That's why they have to talk these people into being witnesses to a case because for whatever reason, but the truth is you don't have to be. So hope that helps out. But guys, we got two classes. Trust administration class is going to be July the 26th. And then we also have the hidden ledger class, which is also going to be August the 9th. Okay. So tonight, and you have up until 12 o'clock Central Time, 12 a.m. Central Time. Okay. Tonight, to be a part of these particular things at the price I'm going to tell you today. So right now, if you want to know fully how to administrate the trust, if you want to know how to place your human capital into the trust, if you want to know how to use the rule of law and do motions to intervene with your trust, how to continue to gain your interest and also stop foreclosures, third parties, etc. You're more than welcome to come and take this trust administration class. We're going to be in Fort Walton Beach, Florida, July the 26th. It's $200 for live stream. In person is $250. But here is the deal for you guys tonight. Okay, you can go to InGodWeTrustAcademy.com. That is our website. But first, before you do anything, go to send us an email at admin, ADMIN, at InGodWeTrustAcademy.org. Again, that's admin at InGodWeTrustAcademy.org. And put discount, okay? Send us an email saying discount, and I'm going to give this class to you tonight at $125 for the live stream, okay? And same for this class, the Hidden Ledger class. It's going to teach you about banking and how to basically get the money back for your deposits. All right. So this is also going to be in Texas. So we'll be in Missouri City. So basically Houston, around that particular area. And remember, send us a discount email, admin at InGodWeTrustAcademy.org. Send us one for discount and put Hidden Ledger. So if you want a discount for either Hidden Ledger or Trusted Men, or maybe both, just let us know. And remember, you will get a $125 for you guys on the discount. All right. Now, that's for till 12 a.m. So you have till 12 a.m. to send us that email. Anything after 12 a.m. on the email part, I said the email, okay? Because we're going to send you a code. And then whenever you choose to get ready to use that code, it's up on you. But however, we're only just send us the email. You will still be able to get it. So you have 12 till 12 a.m. tonight. All right. 2 more hours, literally, Central Time, to be able to place that in with us and be able to lock in at that price at the class with us. Comes with Definitely replay everything like that you'll be getting. Comes with a few ebooks. It's also trust administration is going to be like three classes in one. So we're going to do a lot: asset protections, private administration, and the trust administration. It's all going in there, as well as I'm thinking about for the people that come in person. I'm going to add my declaration of trust class. If you already have that class, then I'll work something else out with you on another one of those other classes if you come in person. But you got to come in person. Those who come in person is going to get a little bit more because they actually took the time to come see me. So always appreciate it for sure. And just, love the fellowship. Conferences are always great and great to meet people and, rock out with you guys. But you guys got some questions right now? Ask some questions. I'm more than welcome to ask. I mean, to answer anything that you guys got on your mind at this time. So what's up? I got time tonight. What y'all want to do? I got time tonight. What kind of questions y'all got? Don't be scared now. Please ask. Don't mind answering. What y'all got in mind? What's all this info for? What do you mean? What is it for? That's kind of a broad question, very broad. What info? Be specific. What info are you talking about? What it's for? If you just want to speak in general, it's for you. It's for you to understand how to literally maneuver through this system and make it for you. How is it beneficial to our everyday lives? Very beneficial. Learning how to, one, operate within the trust can give you tax benefits as well as protecting your assets from third parties trying to sue you. It can also bring you wealth in many different ways, easy to transfer, skipping probate and things of that nature. And also, knowing your rights and knowing when to do and how to maneuver through things, right? Um, Other than that, you know what I mean? It's just up to you. You being able to fully apply. What are all documents that are inside of a trust? Oh, man, it could be a lot. Um, I'm just gonna say, what do you need to establish a trust? It's just a declaration of trust and a subject matter. So that means that a declaration of trust and the actual subject matter is the asset that's being conveyed into the trust for another. That's all you need to establish a trust. That's it. Nothing else. Okay. How to put name in trust? One or two ways. You can also claim the use of the name, etc. And also you can trademark it and place it into the trust too. You can do it that way. When opening a non-interest bearing account, is it normal for the bank to ask to see your full trust? Some of them do, but you can tell them for private reasons only they can get a certificate of trust. But a lot of them like to know exactly how they're operating according to the actual trust to make sure that the trust is within their policies to accept. So they do it in that way too. But I mean, it could be a lot that's involved in documents that's placed into a trust. But for the most part, what sets a trust up is just a declaration of trust and the actual subject matter. So make sure you understand that there's a grantor, there's a trustee, and there's a beneficiary whom the actual particular subject matter is being held for. That's a trust. Now, whether you want to consider the trust revocable, irrevocable, um, of that nature, then that means that you have to determine whether you want to give the grantor rights and interests to have still within it. They sent me, hey, give us 80 days. Is there a time limit? No, there is no time limit. They gave you how many days they need to process of what you're trying to do. Hmm. Any more questions? What y'all got for me? When you file an affidavit of facts, do you mention your trust and do you add your invoice to charge for your time at the court on this affidavit? I would not do it in the affidavit. I would literally put it in the actual, unless you're talking about some type of trust property. It depends on what's being said in the affidavit of facts, what the actual situation is. If it relates to something that relates into it with trust property, then sure, you can mention the trust. But however, remember, you can just use the trust itself, and anything that is dealing with the trust private business, you send privately outside out of the court. Other than that, you got to follow the rules and procedures of the court. How long did this take to get set up? It doesn't take long at all. It takes you is about as long as what are you wanting to set up? The trust? We can set up a trust in 5 minutes. It don't take long to set up a trust. And what I mean by that is just sometimes people only have one thing that they're going to convey to start a trust, and that's it. Type of the documents, type the rules, um, state the governing law, sign it, date it, it's done. I mean, it just depends on how far you want to go with it. They wouldn't just accept the certificate of trust. Understood. Sometimes they don't. Mm-hmm. Sometimes they don't. Anybody else? What kind of questions y'all got? How do we automatically have interest in the contract? Well, you got interest in any contract that you have signed for the obligations that you want to be performed for you. Um, People got to understand that tax also means duty, obligation. Sometimes payment is performance. So you got an interest in a lot if you want something to be done on your behalf, etc. Then that's within the contract. You have an interest in it. That's your right of interest. And then when you talk about other things, interest into the contract, far as you know, the dividends and principal payouts that's going to be created from it being securitized, then that's another situation. But you got to make sure you set up in a way to claim those particular things. And you can claim them. It's not hard to do, but you do definitely have to make sure that you perfect your secured interest. Spaz 21, what's your question? I'm trying to answer y'all question to the fullest, but some of y'all questions are a little vague. It's like super broad. Like it's kind of hard to say if you're not going to pinpoint me in the specifics of the questions that you're asking. Well, let me know, man. Right now, you can get the trust administration instead of for 200. It is 125 tonight. Make sure that you send a email to admin at ingodwetrustacademy.org. Send us the word discount. Let us know if you want it for the trust administration and or hidden ledger or both. Either way, we will make sure you get the code and then you'll be able to go from there. Yeah, I remember your streetwalker term. I just joined this live and I don't know how to go about doing majority of what it is you're discussing, but I'm ready and want to do more than set up a trust. Can you give me a step-by-step guide? Yes, that's what I create is step-by-step guide. So I do actually have a class that speaks on declaration of trust step-by-step guide. We just did that. I also have one before that we did was the In God We Trust conference, which has a whole lot more in it as well too. But um, when it comes to operating in courts and stuff like that, I have another class that talks about Mastering Lawsuits, that's the class, and Defend and Conquer, that's another class that talks about it. And we just did a small little podcast not too long about last week on due process, and I did a ebook with that. So I got plenty of ebooks on my actual website, but it's all there, literally written out step by step. So I talked to you on here a few days ago about my girl Case Streetwalker. So look, how could we use trust, or like could we? She has a warrant out, and I mean we've tried to quash it, but screwed up. It's a lot that you're gonna have to do. Then you're not gonna have. You can't screw it up. What did y'all do with the motion to quash? Explain that. If I exhausted all available remedies in the lower court and they continue to violate my rights, what can I file in the higher court to stop the lower court from proceeding further? A prohibition. I believe the document I need to file is a motion that starts with the letter P. No, you need to file a prohibition, petition of prohibition into the higher court. But I can't recall the exact name. Also, do I need to initiate a completely new case in the higher court? No. The higher court is just the appellate court that's going to look down at what the lower court is doing. So you need to be able to go to the higher court and do a petition of prohibition to stop them from doing any form of procedures that's going to cause irreparable harm. That's what you need to do. Twice. And her grandma has custody of her kids. She's sick. So how could we handle this? So if anything happens to her, we get custody of the kid, and the family is crooked, but I guess. But why K with the warrant? Okay. It's difficult to obtain anything, housing, job, traveling. All right. Well, I don't know. I would have to actually know the whole entire situation, what was filed, what's been filed, to really speak on anything further. But I'm always gonna say it's due process. And if you're familiar with due process, how do I access these classes? In God We Trust Academy.com. But if you're familiar with due process, then you will see uh, that it's very important that you follow due process and that they follow due process. And once you find due process has not been followed, then that's when you get to bring those things up in a manner in court to challenge or dismiss the case based upon violation of due process of law. But I would have to see everything to fully know. A All right, does a trust have what? You didn't finish your sentence. Kind of left me blank there, buddy. What's up, Nick Latham? Just motions to quash the warrants were filed, and continuing, she agreed to a class, or they would give her 6 months in jail time. Okay, so where are you at in the case now, though? When they make us give them everything in collateral, at what point we give them our security agreement? You need to rewrite that. You guys, slow down with what you're writing. I know you want to get it out there, get your question out there because you want me to read it, but when they make us give them everything in collateral, at one point we give them our security agreement. What do you mean when they make you give everything in collateral? Explain that to me. And Slim Jimmy, you gotta write your whole question out. I don't know what you mean. I think if you're asking me about when you sign like mortgages or cars, and then you somehow place those into into the security agreement, they have a secured interest. I think that's what you're asking. I'm not quite sure, but if that's so, then remember, I guarantee you, you can go look up your car right now, and they do not have a UCC perfected on your car. They don't have it. Okay. Now they'll be like, oh well, they got it down at the DMV. It's filed at the DMV that there's a lien on the title, etc. Okay, yes, but that don't mean they perfected it. To perfect it is through the UCC. Do you offer one-on-one mentorship? I have different services for situations, certain services, and I do consultations, but I haven't started a mentorship program. Haven't done that. But I'm on here a lot. I'm on here a lot. But you got first in right and first in time if you have the actual security agreement. So that's why I say, what think about everything that they're using of yours. Y'all have like, and it's just me thinking again, man. I'll be talking about just trust. Okay. The trust is so powerful that you got to understand that the trust can literally just, especially, let's say you got the name trademark, it can pop up to any one of these particular corporations that has been selling the source data of the name and information. If it sells, so let's say if one of these particular companies sells information to Experian, and Experian sells the information for anybody that's trying to get credit, check a credit report. All right, all of them are using trust assets. Everybody has to pay. Everybody, if you assert your right in that. That's what I mean by trust administration. And let's just say that you're trying to get something and they are reporting causes you harm. That's a form of defamation as well. All right. Not only did they call you harm, especially if they remove it, bro, that's a full lawsuit. You should get paid because it caused you harm. That's the thing about commerce, man. It ain't no I'm sorry. It's you cause harm, you pay. Forgiveness is by relief. That's how forgiveness happens in commerce. There has to be a relief given. So, you got to make compensation. To ask for forgiveness, you have to forgive. What are you giving? Right? I have a traffic case scheduled for August the 12th. I already have your template and the class materials on file in motion. My question is, would it be better for me to intervene in the case as a trustee of my trust, or is it sufficient to simply file my affidavit in motion as is? I'm trying to decide whether I should go ahead and file now or wait until later this month after I complete the trust administration class. I mean, it's up to you. What do you want to do? First you gotta know, what does the trust have an interest in this particular case? Does the trust have any interest in the venue that's going on? If so, then you need to make sure that you claim it. But other than that, of course, if you know how to operate through due process and the procedures and the rule of law of the court, then you're gonna be perfectly fine. How do you go about bringing a claim against a credit company like that about? Rewrite that again, bro. I have to make sure when I answer these questions. What date and time are you giving classes at Missouri City? It's going to be August the 9th, 10 a.m. Central Time, right? Maestro's Barber Academy, and live stream. It's 200, in person 250, but right now today it's 125, and that's the hidden ledger. So send us an email at admin@ingodwetrustacademy.org. Write discount, and you'll be able to receive that at 125. A discount code will be given to you. You can use it at any time that you may choose. And no, you can't give it away. It will be specifically for you. Only your name will be attached to it when you go to check out to use it. And it can only be used one time by you. So just make sure we're aware of all schemes. But however, we are definitely going to give you a chance in that. So how do you bring a claim against a credit company when they use trust assets? I mean, through the private administration. It's just like right now. Let's say you that credit company and you're using trust asset. I'm going to send you a notice of security interest and notice of liability which is pretty much the same. And I'm basically going to send you a legal title showing that the asset belongs to the trust. And I will send you a certificate of trust showing you that the trust exists and that as a trustee, I have delegation of authority. And that'll clear all of that mess out for you. And from that point on, I'm just going to send an invoice along with it and just explaining how this belongs to the trust. And now that you owe the trust, you need to compensate the trust because this has created a implied contract and a constructive trust. So now that means that you have the duty as a trustee through a constructive trust to pay me for the use of the property and or cease and desist. Is how I would handle that. I will give you a certain amount of days until you default. Once you default, I'm going to add that into my evidence. And then I'm going to go, I tried to do a set off with you. That's a form of a tender of payment too. Okay. Yeah. That is a form of a tender of payment by trying to do a set off. So after I do that, we'll do a declaratory judgment. Okay. And once we do a declaratory judgment on it, we'll get what we want. If they are trying to, the credit company trying to sue us or pursue us in any shape, form, or fashion, then that's when we'll go into a full motion of discovery in court and make them produce everything on the record because we're going to make them validate the debt. So now they would have to come to court, prove chain of title. Yeah, we want to see that. And when I say chain of title, I mean chain of title of the actual note. We want to know who it was transferred to, how many times, etc. Yes, because every time and what was the discount? Because any monetary value that was made, that interest belongs to the trust. We want it. Do you know how to access funds connected to your social security number? I just told you. I literally just told you. I literally just told you exactly what to do. The funds that's also connected to your social security numbers is the credits that's created when you issue promissory notes to banks. That's your funds. Yeah, that's your funds. Da 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 da. I'm loving it. Let's see what somebody said. Please, 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 can you please do a video on set up the signature, our time, leg, or fingerprint into the trust? I've already done that. Already got classes like that already. Declaration of trust class. That's one. You can go back into the In God We Trust Academy class. Also, the affidavit. I think it's the life estate class we did too. That one. But yeah, I've done it plenty of times. I'm also going to show it in the trust administration. Could you explain how you issue promissory notes? What you mean by that? Because now we're talking about private banking if you're talking about things coming from the trust. And I did that in private banking class that I just had a couple weeks ago. And so many of y'all missed out on that private banking class, yo. I literally showed you in that private banking class how to create your own private banking trust, create your own form of currency. You can place your products, your goods, your service, your labor, your time, all of these things into the trust, and you can back your own currency with it. You can literally make people join. You can start a form of a PMA or just have a trust, totally up to you. But if you do the PMA with along with it, what you'll have is people join you as members, and everything would be considered to be private transactions, okay, in exchange for services that's rendered within this private member association. So when you do it that particular way, there's no taxation. Now, not only that, you also building and creating a ledger that's going to show that you have, number one, proof of funds and you have circulation within your own bank. So if you wanted to go leverage that, you could go get you some money. Simple. But the number one thing is you do have to be industrious. And it's also a way for you to learn how to create a economic community along with others as well. You can do that. So if you wanted to back it with digital coins, dollars, or whatever the case may be, you can do so. And then you can also issue out promissory notes. Now, I'm going to say this. If a promissory note is what created the credits and begin with, I'm sure what happens if a promissory note was created again? Would that not create the money? And let's say you literally gave that promissory note to the bank to handle the sufficient funds to literally of the set off or discharging of any debt. Because if a promissory note is taken from the member banks and then it's transferred to the Federal Reserve goes to the clearinghouse, and then from the clearinghouse, they kick the credits out back to the bank. The bank now puts it down as a form of liability that they owe you. But here's the thing, they have all this interest placed up on it with it, but they're going to do fractionalized reserve banking here. So fractional reserve banking, meaning that, well, when you made a deposit of your promissory note of 80, let's say 100,000, they were able to go create $1 million off of that. Is what you have to understand, because it's a new deposit. So they're going to do fractional reserve banking on that. But my whole point of me saying that is now they owe that to you, but it's also placed upon interest on you. So what you need to learn how to do is, if, again, like I said, if a promissory note created that, then what would another promissory do that is specifically made out to the bank that says that you owe this interest, etc.? Who knows, right? Do I have a class that covers how to create a name trademark? I'll show you how to do that in this trust administration class. Very simple method, not hard to do. Very simple method. Again, guys, tonight and tonight only, you actually have an hour and 30 minutes left. Go send us an email, admin@ingodwetrustacademy.org. Okay? And put the discount. You can get the trust administration class on our website, ingodwetrustacademy.com, at $125, and or if you want the hidden ledger that we're going to do in August in Texas about the bank, like I was just explaining to you, then you're going to put discount for hidden ledger, which we'll also give to you at $125 tonight. So if I'm asking the credit agency to remove things, I can send security agreement. It's no need for you to actually send the security agreement. You can, but it's no need to. If I'm going to send something in, I'm going to make sure that, number one, that the credit agency did its full investigation on what's being reported. And what I mean by investigation, number one, in order for these particular entities to make these claims, they have to have the original note. They have to be the holder in due course. If they do not, then they do not have the valid right to make this particular claim. So make them go and check and see if they have the original note, or if it was monetized or securitized. Or securitized. If it was, then now that means that the note and the actual security agreement have been separated. And since that is so, it's no longer considered a negotiable instrument. So therefore, it's nothing they can do. They can't literally make a claim and report any of these things anymore because they don't have the delegation of authority to appoint those things. So that's why I'm telling you that you need to make sure that you make sure that they do their justice in going to, when it comes to your credit report. What should people do if they have no trust but want to participate in the course trust administration? Come learn. Because it's still going to teach you about the rules, administrating, and how to maneuver and what literally needs to be done when it comes to when you do have a trust. Because a lot of people, even though they got a trust, they don't have not one single idea on how to administrate it. They don't understand how the Constitution is a trust, how to administrate it. They don't understand how the court rules and procedures of the course is a trust and how to administrate. right? Do you have classes on accessing the funds in your treasury? The treasury belongs to all people, not just one. How do you access the funds? Keep doing what you're doing. You just need to get in line. Like, listen, guys, credit will always exist no matter what. No matter how bad of credit you got, you still can go get $100, $200 credit card, $50. You can still get a secure credit card, whatever. Okay? It's literally never ending. People just need to get up on their shit and play the game. It's simple. You can create credit. You can create credit all day. And the better and the more you show that you know how to maintain credit and also learn how to leverage assets, what are we sitting here talking about? It's you. You just need to learn how to operate. All this stuff, the questions that you're asking are literally just forms of myths, and it's not going to operate and work like that. Can you reach into your treasury? You do every time that you go do a promissory note. That's going into your actual form of treasury account that's going to pass this particular promissory note through your ACH account, and it's going to create Federal Reserve notes. That's what it's going to do. But you have to understand you're playing the game and what's actually going on and being aware on how to, number one, shut down these fraud contracts. Number two, any interest that has been created for monetary value, then you get to get those things if you know how to declare your status and rights and interests by common law. Because remember, what's yours, whatever's yours, you have a right and interest in it. If somebody used something of yours to create and make money to elevate themselves, then it's only right that they compensate you for the use of your property. Right? Same thing. They can't take your property and use it without just compensation. That's part of common law. So that's what I'm trying to tell you. It's going to supersede those statutory laws that you guys like to talk about. And statutory laws are fine as long as they are in harmony with the actual Constitution. If that's the case, then everything's great. But if not, hey. So, if you guys are interested, come check us out. We got 2 classes. All right, get you a screenshot going on. This class is going for $125. All you need to do is send us an email, admin@ingodwetrustacademy.org. All right? Send me one immediately. Put discount so we can give you this class for $125. And then literally 2 weeks after, we're going to be in Houston, Texas. So send a discount for this. I'm going to do the same thing. All right? Make sure you come to class to learn this step by step. And also ebooks, templates, whatever you guys need is there provided for you. I got a case dismissed and titled to my car. Can I sue debt collector for not showing delegation of authority and admitting to lying in court? Yes, you can sue them. Actually, you could have did a counterclaim against them in that particular court. Yes, you can sue them. No, it's not. It says live stream is 200, in person 250. If it's on my website like that, I'll change it. I appreciate you saying something. Okay. I guess you're saying it's like that. I guess you're saying it's like this. So let me go look. Let me go and look. I know you're probably right, though. Let's go. You said hidden ledger? Okay. Yep, they both the same. You are absolutely right. I surely do appreciate that. So we will get those fixed immediately. But you will be able to get a discount for 125. So thank you very much for that. Can we go back 5, 10, 15 years if we still have contracts? Can you prove the fraud? Yeah, prove the fraud. That's all you got to do. But yes, you can actually sue the debt collector for lying and all of that. You can still sue them. Anybody else? What y'all got for me, man? If nothing else tonight, again, I appreciate you guys and your time. We'll be back up in the AM locked in. We're going to talk about something else, but at the same time, all of this goes in hand with everything that we're speaking on, from banks to um, court to arbitration to these credit agencies to consumer law. To it's all works the same, right? It all works the same. But with that being said, man, I appreciate y'all. Y'all have a great and beautiful night.